Chapter 17, Homicide. Section 305, Homicide in general. Definition. Homicide is the killing of a human being by a person. The mode of doing it, and the circumstances attending it, do not enter into the definition, provided the killing be done by a person. Strictly speaking, when the killing is not done by a person, it is not homicide. According to Bracton, if it be done by an ox, a dog, or other thing, it is not properly termed homicide. Section 306. Classification. Definition. Homicide is divided into the following three classes. 1. Justifiable. 2. Excusable. 3. Felonious. Blackstone observes, now homicide, or the killing of any human creature, is of three kinds: justifiable, excusable, and felonious. The first has no share of guilt at all, the second very little, but the third is the highest crime against the law of nature that man is capable of committing. It is to be observed, however, that treason is usually regarded the highest crime known to the law. Section 307. Justifiable homicide. Definition. Justifiable homicide is the killing of a human being in the discharge of a legal public duty. Section 308. Justifiable homicide. Execution by sheriff. Where a sheriff or his deputy, in the discharge of his public duty, executes a person who has been condemned to death by a judicial tribunal of competent jurisdiction, the homicide is justifiable. In such case the victim must have been given a legal trial, or confessed his guilt, and the execution must be in strict conformity with the sentence imposed. Thus, if the sentence is that the victim be hanged, and the sheriff execute him by shooting or electrocuting him, the sheriff would be guilty of murder. It is Blackstone's view that the law must require it, otherwise it is not justifiable. Therefore, wantonly to kill the greatest of malefactors, a felon or a traitor, attainted or outlawed, deliberately uncompelled, and extrajudicially, is murder. And farther, if judgment of death be given by a judge not authorized by lawful commission, and execution is done accordingly, the judge is guilty of murder. Also, such judgment, when legal, must be executed by the proper officer, or his appointed deputy, for no one else is required by law to do it, which requisition it is that justifies the homicide. If another person doth it of his own head, it is held to be murder, even though it be the judge himself. It must farther be executed servato juris ordine, according to the order of the court. It must pursue the sentence of the court. If an officer beheads one who is a judge to be hanged, or vice versa, it is murder, for he is merely ministerial, and therefore only justified when he acts under the authority and compulsion of the law. But if a sheriff changes one kind of death for another, he then acts by his own authority, which extends not to the commission of homicide, and besides, this license might occasion a very gross abuse of his power. Section 309. Killing felon to effect arrest or prevent escape. Where one necessarily kills a felon to effect his arrest, or prevent his escape, the homicide is justifiable, and in such case, the necessity is sufficient if reasonably apparent. Moreover, the homicide may be committed by a private person as well as by a police officer. Stephen says, the intentional infliction of death or bodily harm is not a crime when it is done by any person in order to arrest a traitor, felon, or pirate, or retake or keep in lawful custody a traitor, felon, or pirate who has escaped, or is about to escape, from such custody, although such traitor, felon, or pirate offers no violence to any person, provided the object for which death or harm is inflicted cannot be otherwise accomplished. It is to be observed, however, that where even a police officer kills a misdemeanant to effect his arrest, the homicide is not justifiable. The theory of the law being that it is better that a misdemeanant escape than that human life be taken. A few courts have held the contrary, but they do not represent the better view. On the other hand, where a peace officer, in attempting to arrest a misdemeanant, is threatened with death or great bodily harm, and he necessarily kills the latter to save himself, the homicide is justifiable. Moreover, an officer, whose duty it is to preserve the peace, is not required to decline combat, when resisted in his duties, and to put himself out of danger, before he will be justified in killing his assailant. But he will not be justified in taking human life to effect an arrest for a misdemeanor, or in preventing an escape or rescue from such arrest. An officer making an arrest for misdemeanor may resist force by force, and when the resistance is violent and determined, an officer is not bound to make nice calculations as to the degree of force necessary to accomplish the purpose, but may use such a reasonable degree of physical force in overcoming such resistance and effecting such arrest, as may reasonably appear necessary therefore, and to prevent the escape of the party whom he is arresting. But he has no right to take the life of such person, or inflict on him great bodily harm, for the purpose of making such arrest, except when the officer has a reasonable apprehension of peril to his own life. or of suffering great bodily harm. Section 310 Killing to quell riot. Where a person necessarily kills one or more persons to quell a riot, the killing is justifiable. The intentional infliction of death or bodily harm is not a crime when it is done either by justices of the peace, peace officers, or private persons, whether such persons are, and whether they act as, soldiers under military discipline or not for the purpose of suppressing a general and dangerous riot which cannot otherwise be suppressed. This constitutes the one exception to the rule that human life may not be taken to prevent a mere misdemeanor. The reason for this exception is the fact that while riot, at common law, is only a misdemeanor, its consequences may prove very disastrous, and therefore justify a killing where necessary to quell it. It is to be observed, however, in this connection, that a homicide to quell an affray is never justifiable. Nor is a homicide to prevent a mere trespass ever justifiable. Section 311 Killing to prevent felony. Where any person necessarily kills another to prevent him from committing a felony attempted by force or surprise, the homicide is justifiable. In such case it is not essential that the attempted felony be directed against the homicide himself, or against his habitation. It may be directed against the person or habitation of even a stranger. Such homicide as is committed for the prevention of any forcible and atrocious crime, is justifiable by the law of nature, and also by the law of England, as it stood so early as the time of Bracton. The forcible and atrocious crime may be murder, rape, robbery, burglary, arson or sodomy. It does not include any secret felony like larceny. The basis of the justification in this class of homicide is necessity. It is sufficient, however, if the necessity be reasonably apparent. One who is opposing and endeavoring to prevent the consummation of a felony by others may properly use all necessary force for that purpose, and resist all attempts to inflict bodily injury upon himself, and may lawfully detain the felons and hand them over to the officers of the law. Although the use of wanton violence and the infliction of unnecessary injury to the persons of the criminals is not permitted, yet the law will not be astute in searching for such line of demarcation in this respect as will take the innocent citizen, whose property and person are in danger, from its protection, and place his life at the mercy of the felon. Section 312 Excusable homicide. Definition. Classification. Excusable homicide is the killing of a human being under circumstances which constitute an excuse for the act rather than a justification of it. This class of homicide is of two kinds: 1. Homicide by misadventure. 2. Homicide in self-defense. Section 313. Excusable homicide. Homicide by misadventure. Homicide by misadventure is the killing of a human being by a person engaged in doing a lawful act with due care and without criminal intent. The decisions contain many examples of this class of homicide. Among them are the following: 1. One person accidentally kills another while playing football. 2. A physician, in procuring an abortion where it is necessary, at least apparently, to save the mother's life, unintentionally kills the mother. 3. A workman, after shouting warning, throws a piece of timber from a housetop and it strikes and kills a person. 4. A steamboat, whose lookout is exercising due care, runs down another boat and lives are lost. 5. A physician, in the exercise of due care, unintentionally causes death by administering a dangerous drug with the view of performing a surgical operation. 6. A parent moderately punishes an offending child, or a teacher his pupil, and death ensues. 7. A person is using a hatchet with due care and the head flies off and kills a bystander. 8. A man, in the exercise of due care, shoots at a target and the ball glances off and kills a person. 9. A watchman in a park, mistaking his master for a poacher, shoots and kills him. 10. A person, while lawfully defending himself against the assaults of another, shoots and unintentionally kills a third party. On the other hand, if, in any of the foregoing examples, the perpetrator were guilty of negligence, the homicide would be manslaughter, and if guilty of malice it would be murder. Section 314. Homicide in self-defense. General requisites. Homicide in self-defense is of two sorts: justifiable and excusable. By statute, however, in some states all homicides in self-defense are justifiable. To render a homicide justifiable or excusable on the ground of self-defense, the following conditions are essential. 1. Imminent danger of death or serious bodily harm to the slayer must be at least reasonably apparent. 2. When the danger is only apparent, the slayer must believe, on reasonable grounds, that it is real. 3. When the killing grows out of a sudden affray, the slayer, before killing his adversary, must retreat as far as possible with safety. 4. The slayer, as a general rule, must not be the aggressor. Section 315. Homicide in justifiable self-defense. This kind of homicide is committed when a person without fault, who is feloniously assaulted, necessarily kills his assailant to prevent him from committing a forcible felony. Where a woman kills a man necessarily to prevent him from committing rape upon her, or a man kills another person necessarily to prevent that person from killing him, or inflicting serious bodily injury upon him, or robbing him, the homicide is justifiable. Section 316. Scope of the necessity for the killing. The necessity for the killing is sufficient if reasonably apparent. The law does not require it to arise out of actual danger in order to excuse the slayer. He may act upon a belief arising from appearances, which give him reasonable grounds to believe that the danger is actual. His guilt must depend upon the circumstances as they appear to him, and he is not responsible for a knowledge of the facts, unless his ignorance arises from some fault on his part. An instruction that to justify a person in killing another in self-defense, it must appear that the danger was so urgent and pressing that in order to save his own life, or to prevent his receiving great bodily harm, the killing of the deceased was absolutely necessary, is erroneous. Section 317. Retreat unnecessary. In this class of homicide the party assaulted is not bound to retreat at all. Since he is without fault he may stand his ground and, if necessary to save his own life or prevent serious bodily harm to himself, kill his assailant. A true man, who is without fault, is not obliged to fly from an assailant, who, by violence or surprise, maliciously seeks to take his life or do him enormous bodily harm. Section 318. Homicide in excusable self-defense. In this kind of homicide the slayer is not without fault. In this respect it differs from homicide in justifiable self-defense. It is committed when a person who is engaged in a sudden affray necessarily kills another person in it to save himself from death or serious bodily harm. At common law it was punishable by forfeiture of goods. According to Coke anciently it was punishable by death. Later writers, however, deny this. Blackstone says, "The penalty inflicted by our laws is said by Sir Edward Coke to have been anciently no less than death, which, however, is with reason denied by later and more accurate writers. It seems rather to have consisted in a forfeiture, some say of all the goods and chattels, others of only part of them. At present, however, it is not punishable at all, either in England or in this country. The affray, from which this kind of homicide may spring, may arise in various ways, as from resenting and returning a blow, from resenting insulting words, from resisting a trespass on land or goods, or from resisting an unlawful arrest. It is to be observed, however, that none of these provocations, of itself, excuses a homicide. Section 319. The danger must be imminent. To render the homicide excusable, the danger to the slayer must, at the time of the homicide, be at least apparently imminent and not merely prospective. The danger, or apparent danger, must be present, not prospective, not even in the near future. If it be prospective, it may, in most cases, be averted in various ways, as by taking shelter in one's own dwelling, having the would-be assailant arrested, etc. Human life must not be sacrificed under the apprehension of a prospective, probable danger, even in the near future. When there is no necessity, real or apparent, to slay an adversary to save one's life or person from great harm, there cannot, in the nature of things, be a right to kill in self-defense. Section 320. Facts admissible to prove danger imminent. Any fact which tends to prove that the slayer was in imminent danger at the time he committed the homicide is admissible in evidence. Thus, it may be shown that deceased had made threats that he would shoot the slayer at sight, that he carried arms, that he attempted to draw from his pocket a weapon, that he lay in wait, that his character for violence or lawlessness was bad, etc. Section 321. Evidence right of attack in self-defense. It is sometimes said that the right of self-defense does not imply the right of attack. This, however, is not strictly true. When a person has reasonable ground to believe that another person intends to do him immediate serious bodily harm, and that such design will be accomplished unless prevented, he need not wait until his adversary gets advantage over him, but, if necessary to avoid the danger, he may kill his would-be assailant immediately, and the killing will be justifiable, although it may afterward turn out that the appearances were false, and there was, in fact, neither design to do him serious injury nor danger that it would be done. Section 322. Evidence. Actual danger not essential. A few cases hold that actual danger of death or serious bodily injury to the slayer is essential to render his act excusable self-defense. The better view, however, as well as the great weight of authority, is to the contrary. The rule is that, a bona fide belief on the part of the slayer, founded upon reasonable grounds, that he will suffer death or great bodily harm unless he kills his assailant, will excuse him to the same extent as if the danger were real. Thus, where a person has threatened to take another's life at sight, and upon meeting the latter makes a movement as if to draw a weapon to carry out the threat, and the other party, under a bona fide belief that it is necessary to kill him to save his own life or prevent great bodily harm, takes the life of his would-be assailant, the homicide is excusable, though it appear later that the deceased was unarmed. Section 323. Evidence grounds of apprehension must be reasonable. It has been held that a homicide may be excusable where the slayer's apprehension of death or serious bodily harm results from cowardice on his part, rather than appearances. This view, however, is erroneous, and not at all in harmony with the great weight of authority. The law makes no discrimination in favor of a coward, a drunkard, or any particular person. The circumstances must be such as to justify the fears of a reasonable man. A homicide is not excusable on the ground of self-defense unless the danger of death or serious bodily harm is actual, present and urgent, or the slayer has reasonable ground to apprehend a design, on the part of the would-be assailant, to commit a felony, or do him some great bodily harm, and there is imminent danger of such design being accomplished. The mere fear, or belief, however sincerely entertained by one person, that another intends and designs to take his life will not justify the former in taking the life of the latter. Merely an attack with fists or mere threats of injury will not excuse killing another. Where the danger is neither real nor urgent, to render a homicide excusable or justifiable within the meaning of the law, there must, at the least, be some attempt to execute the apprehended design, or there must be reasonable ground for the apprehension that such design will be executed, and the danger of its accomplishment imminent. It is not essential that an actual felony should be about to be committed in order to justify the killing. If the circumstances are such as that, after all reasonable caution, the party suspects that the felony is about to be immediately committed, he will be justified. Section 324. Evidence. What constitutes reasonable caution? The correct standard. The imminency of the danger and the necessity of the killing must, in the first instance, be determined by the slayer. In doing so, however, he acts at his peril, as the jury must pass upon his actions in the premises. The jury, however, must view those actions from the slayer's standpoint at the time of the killing, and if they believe, from all the facts and circumstances in the case, that the slayer had reasonable grounds to believe, and did believe, the danger imminent, and that the killing was at least apparently necessary to preserve his own life or to protect him from great bodily harm, they should acquit him. It is important to remember, in this connection, that the question of apparent necessity for the killing must be determined from the slayer's standpoint. A reasonable apprehension in the mind of a man of ordinary intelligence and courage is not the standard. The belief of the ideal reasonable man is not admissible to acquit, a fortiori, it is inadmissible to convict. In such a case the following instruction is correct, as to the imminency of the danger, which threatened the prisoner and the necessity of the killing. In the first instance he is the judge, but he acts at his peril, as the jury must pass upon his actions in the premises, viewing said actions from the prisoner's standpoint at the time of the killing, and if the jury believe from all the facts and circumstances in the case, that the prisoner had reasonable grounds to believe, and did believe, the danger was imminent, and that the killing was necessary to preserve his own life, or to protect him from great bodily harm, he is excusable for using a deadly weapon in his defense, otherwise he is not. The purpose of showing that the defendant had reasonable grounds to believe that the danger was imminent and the killing necessary, threats, menaces, assaults, lying in wait, carrying arms, the character of the deceased for violence or lawlessness, the circumstances of the meeting, and any other facts tending to show that the slayer was in peril at the time of the homicide, are admissible in evidence. Section 325. Evidence. When duty to retreat exists. Distinction between excusable self-defense and justifiable self-defense. Where two persons engage in a sudden affray, both being in fault, each is bound to retreat, if possible, before killing the other in self-defense. Blackstone thus states the rule: the party assaulted must therefore flee as far as he conveniently can, either by reason of some wall, ditch, or other impediment, or as far as the fierceness of the assault will permit him. On the other hand, where a party without fault is attacked by another, he is not bound to retreat. He may stand his ground, and if necessary to save his life or prevent serious bodily harm, he may kill his assailant. It is now well settled that the accused, when not in fault, is not compelled to flee from his adversary who assails him with a deadly weapon. It is to be observed, however, that where both are in fault the accused must cease the combat and retreat as far as safety will permit before he is justified in taking a human life on the ground of self-defense. Justice Sylvain says, by observing the distinction between justifiable and excusable homicide se defendendo, as stated in the authorities above quoted, much of the discrepancy in the decisions of the courts where the common law prevails is made to disappear, most of the cases upon the facts being such as would only excuse the killing. It is true, under our Constitution, whether the killing in self-defense be justifiable or excusable. There must be an entire acquittal, for the reason that there is no forfeiture of goods in cases of excusable homicide. But this is no reason why the difference between the cases as to the duty of retreating to the wall should be ignored. The taking away of the forfeiture in cases of excusable homicide did not relieve the party in such case from the duty of retreating, nor did it impose such duty in cases where it was not before acquired. It is true that all authorities agree that the taking of life in defense of one's person cannot be either justified or excused, except on the ground of necessity, and that such necessity must be imminent at the time, and they also agree that no man can avail himself of such necessity if he brings it upon himself. The question, then, is simply this: does the law hold a man who is violently and feloniously assaulted responsible for having brought such necessity upon himself, on the sole ground that he failed to fly from his assailant when he might have safely done so? The law, out of tenderness for human life and the frailties of human nature, will not permit the taking of it to repel a mere trespass, or even to save life, where the assault is provoked. But a true man, who is without fault, is not obliged to fly from an assailant, who, by violence or surprise, maliciously seeks to take his life or do him enormous bodily harm. The right of self-defense is the right to repel force by force unlawfully exerted. The repellent force is protective and not aggressive. When full protection is achieved, the legitimate end of this repellent force, which the law allows, is accomplished, and at this point it should cease. Section 326. Defense of third persons, dwelling, or property. Homicide may be justifiable or excusable in the defense of third persons, as a wife, child or near relation, where the circumstances reasonably justify one in believing such person is in imminent danger of death or serious bodily harm. This rule may be applied to the defense of persons not relatives. But one defending a third person has no greater rights than such person would have in defending himself. Homicide may also be justifiable in defense of one's dwelling, where it reasonably appears necessary to kill in order to prevent the felonious destruction of one's property or habitation or the commission of a felony therein, or to defend one's self and family therein against a felonious assault upon life or person. Section 327. Felonious homicide. Definition. Classification. Felonious homicide is the killing of a human being without justification or excuse. In other words, it is the unlawful killing of a human being. This latter definition, however, does not apply to conditions as they existed at common law, for the reason that excusable homicide was punishable by forfeiture of the slayer's estate. At present, however, both in England and in this country, the penalty of excusable homicide, which existed at common law, has been swept away. In felonious homicide there are at common law 2 degrees of guilt, which divide the offence into the following crimes: 1. Murder. 2. Manslaughter.